start, the grievance of the appellants is that through impugned orders passed by revenue authorities, they were given less landed property through separate portion, and that the landed property which was under their possession was delivered to defendants. Stop. The learned counsel for the appellants has stressed upon the point that at the time of pendency of partition applications before Tehsildar Lahore, appellants number 18 and 19, namely Muhammad Latif and Ramzan Bibi, were minors and they were not sued through next friend. Stop. Next, he has argued that the issues number 1 and 4 were jointly decided and no separate findings were given on said issues by the learned trial court. Stop. The appellants plaintiffs have admitted in their plaint that they also filed separate application for partition of joint holding. Stop. When they were petitioners in the said proceedings, the non implemented of said minors by the other petitioners in their application was not fatal. Stop. Moreover, in partition proceedings, all the parties are petitioners, plaintiffs, as the case may be. Stop. The issues number 1 to 4 were pertaining to impugned orders passed by the revenue authorities. They were concerning the same proposition, that is why they were discussed and decided together by the learned trial court, which fact does not constitute any illegality or irregularity in this regard. The scanning of record reveals that the present parties are progeny of four brothers, namely Nizamdin, Muhammad Ali, Abdul Karim, and Khushi Muhammad, who were joint owners of piece of land measuring 42 k 17 m, which they privately partitioned, and fact of partition was depicted in the documents of receipt of land revenue with an agreement dated 10/3/1957. Stop. Para. This is the pivotal issue which is taken up first. Stop. The version of plaintiff is that defendant borrowed an amount of rupees 3,50,000 and issued the impugned check exhibit P1 to him for it repayment to plaintiff. Stop. Now the position is that the defendant has admitted issuance of impugned check in favor of plaintiff. Stop. The execution of said document is thus admitted on record. Stop. In this way, onus stands shifted to defendant to prove his plea, which he has taken in the written statement that in fact he issued the impugned check to plaintiff as surety/security on the promise of plaintiff to get younger brother of defendant employed in army. The impugned checks dated 29/5/2010. Stop. Suit in hand was filed on 22/10/2012. Stop. The plaintiff has alleged the transaction in the year 2008. Stop. If the transaction for the sake of arguments is not admitted to have taken place in the year 2008, even then the check was admittedly issued prior to crucial date, that is 28/5/2010. Stop.